Hi, my name's Isaac Shutt. I'm a licensed attorney to practice law both in Texas and Wyoming. I practice mostly in estate planning law. Today we're going to talk about divorce and the impact of divorce on a last will and testament and some other estate planning documents under Texas law. So I'm going to talk about this in sort of two different ways. The first way is sort of, if you don't change your estate plan, what happens to your will and other documents if you get divorced in Texas? So the really great thing is, under Texas law, if you get divorced, any reference to your former spouse in your last will and testament is automatically nullified. So for example, if you and your spouse had done a last will and testament together and you had said, okay, if I pass away, I want everything to go to the other spouse, and I'm also going to list my spouse as the executor when I pass away, after the time that you signed that will, if you subsequently divorce from that person, the mention of your former spouse as executor or as a beneficiary is automatically null and void. That just happens by operation of law. I think that's a really good law, by the way. I think it's really great because that's what most people would want. And so by default, your will is automatically updated, and that's really awesome. Now, I will say that is not good enough for me. So I think that as an attorney, if you think you're going to get divorced from somebody, go ahead and update your estate planning documents. Don't just rely on the default that says that your will would automatically remove that spouse. And I say that for two reasons. Number one, we've already had this happen before where somebody has filed for divorce and then dies before that divorce is finalized. And if that divorce isn't finalized, that person that you were in the process of divorcing will actually inherit everything under that will. Because until that decree is signed, it doesn't matter that you're separated, they're still legally, technically your spouse, and so that will would basically give everything to that spouse that you're no longer together with. So I would say, number one, if you're even thinking about getting divorced, when you go and talk with your divorce attorney and that kind of thing, definitely put that on your task list that you need to change your last will and testament. And you can do that right away. You don't have to wait till the divorce is final, and shouldn't wait until the divorce is final to update your will. Go ahead and do that now. So if you have a will or a trust or things like that, don't wait. If there's a divorce that's filed, go ahead and update your estate planning immediately so that if something happens to you in the interim period, everything will be taken care of the way that you actually had wanted. The other thing that I would say is, aside from the comment that I just made, the reason I wouldn't just rely on sort of the default that says automatically your spouse would be removed from your last will and testament is that even getting that accomplished, meaning if you pass away and your former spouse is still listed as a beneficiary or executor in your will, basically the other family member may be basically fighting your former spouse to prove the law to the judge that, hey, judge, this is a former spouse. This former spouse shouldn't be a beneficiary, even though he's listed as a beneficiary in my will. And you'd have additional legal fees. Your family would have additional legal fees and hassle to potentially fight your former spouse in establishing for that probate court that, hey, that surviving spouse is not supposed to be the executor and not supposed to be a beneficiary. It is definitely worth it in terms of cost and hassle to go ahead and update your will so as to not leave a mess for your surviving family if you pass away with that old pre-divorce will. So it is so much easier, cleaner, less expensive, less stress, less hassle, all of that, to go ahead and make a new clean will once a divorce is filed. So automatically by default, that spouse would be removed, but to me, that's not good enough. If you're going to file for divorce, or if your spouse has filed for divorce, go see an estate planning attorney, get that will updated. Your family will sure thank you. And I hope you found this video helpful. Again, my name's Isaac Shutt. I'm an estate planning attorney headquartered in Texas.